So hello to everyone. And we're not going to talk about rape, not about murder, not about... We're going to talk about magistrate courts and about the door that we think is really the prominent door, at least that people today see as the door of criminal justice. Because this door is really transforming and changing, and part of the questions is how do we really regulate or address the new kind of negotiation that happens in the courtroom. I know even Malcolm has written about it, and many people in this room are interested in it, but and we are doing it as part of a broad research project that deals with the changing role of judges in an age of vanishing trial, and conducted in 3 countries. We will speak mainly about Israel, but throughout the conference we'll also go to the other comparative aspects of this research. And I'm privileged to conduct this research together with a few partners that are all in this room. Sari, Luz-Kanner, Dana, who will present to me, Yosef Zohar, who was also leading, collecting the data and leading the students, and this is an empirical study. So I'll start with some introductory comments. First about the project, and then about this presentation, and Dana will present the findings. So we're interested to understand what judges do in a multi-door era, in an age of vanishing trial. And empirically, this research, and this goes for the 3 countries that we deal with, we try to understand the phenomena of settlement and its relationship with conflict resolution, and understand and conceptualize judicial activities from this perspective. And I emphasize this perspective because we can look at it from an efficiency perspective, managerial perspective, and we can look at it just in order to describe it. I'm interested to describe it in order to expand it. I think part of the presentation before was also about these questions, and the question whether these gaps creates an opportunity, and therefore we look into judges' activity, but we search for certain activities that are of interest for us and that are related to our inspiration, which is conflict resolution. In terms of a normative stance, we would like finally to have recommendations. We are building now a training unit for judges together with the court headquarters, and we try to take this knowledge and make it workable for judges. And the panel that we have tomorrow together with judges is meant to think about the real instances that happen in reality, and how should they be trained in order to deal with it. And in terms of theory, I think this changing world of law, the multi-door phenomena, brings a lot of jurisprudential questions when we speak about adjudication through persuasion, when we speak about settlement as the norm, when we speak about even death penalty in the shadow of plea bargain. Everything, part of the question is today, what is the shadow? Because the shadow is many times the plea bargain. We do restorative justice in the police, the shadow is the plea bargain. We do death penalty, the shadow is the plea bargain. From all directions, the question of what is the mainstream process of law is really ignored. And adjudication is declining in all terms, and it's the full-blown adjudication is so expensive, it's so hard to handle that it almost never happens. And then what we have is this terrain of endless negotiations and very particular case-based and types of criminal conflict-oriented practices that we should study and try to think about how to improve, but it has theoretical consequences. It's not only about just training people. So in terms of the background for this presentation, I will briefly go over these 5 themes. Part of it is the question of plea bargains and the vanishing trial, the relationship to conflict resolution, the role of criminal judges, and the research field that we examine, the Marquette days, the criminally preliminary hearings in Israeli courts, and the comparison to the civil trial. we started the research with focus on civil judges. Everybody said, start with this, it's easier at settlement, and leave the criminal later. Later we moved to the criminal field and also were challenged a lot about comparing between them, but I'll try to show that there is a reason to compare. And there, basically, judges are not doing so different things, and it's important that civil people will talk to criminal people in order to see what are the differences and what are the similarities. So in terms of plea bargains and the vanishing trial, so we have vanishing criminal trials in many systems, and apparently also in inquisitorial system. We'll speak about it later, but now we'll speak about the common law and adversarial system. And plea bargains are become institutionalized, and the criminal proceedings are shortened, and in a sense, most of them end in the preliminary hearing, and at least in Israel, the parties are, the defendant, the parties are barred from pursuing to the next stage, meaning the judges stand there and they really put a lot of pressure to end it in this stage, and therefore preliminary hearings become the most important scene of criminal justice in this kind of. And there are waiver system widely spread in many places, and here we have some data, but even in Israel, for example, we have this data about 76.5%, but even more cases and in agreements, meaning that some verdicts are given in the preliminary hearings. So we have a lot of trials that end not in a full-blown adjudication following the full procedure, and therefore the other option is what we would like to study. And it's all based on efficiency, and there are some elements of ADR that are in the margins, and conflict resolution like community courts. We have some ideas of rehabilitation, but as we will see later, we don't find many of them. Later we could find, but we don't find a lot of emphasis on that. In terms of the relationship to conflict resolution, part of my perception or my idea in pursuing this research is the perspective of the social conflict that underlies the criminal dispute, and the question about the real parties that are related, the victim, the offender, the community. And then on the top of it, there is the juxtaposition of the criminal charge. But if judges are in the scene of negotiation and have this direct encounter with all the parties, so part of the question is how do we insert and how do we implement principles of conflict resolution, and we address the social conflict inside the criminal justice system. And I'm thinking also about restorative practices in small scale and not necessarily the full process. And there are also ideas today of social rights, of people coming at least to the magistrate court. Sometimes they have a problem of, shelter, of health problems, and the court is there like an agent that sometimes can really fulfill the other rights and be in charge of it. So the question of the relationship between plea bargain and conflict resolution is part of this inspiration for the observations. And in terms of the judge, just to say quickly, because I want to go into the finding, there is the idea that, and originally when I started the research, say judges are not involved at all in plea bargains, just, give up on this part of your research, it's not relevant to the criminal stuff, only in civil cases they are involved. There is the idea of passive judiciary, and that it's all between the prosecution and the defense, and it's a managerial scene, and finally, it's really not the idea, but this finding is about managerial judges and more active judges. Marquette days in Israel started in the 90s, and they are like the main door for all the defendants that are in the level of the magistrate court. Sometimes there used to be 60, 50, sometimes today 40 cases. It's a lot of cases that are condensed for one day, and this is like a train of deals, and most of the deals, as you will see, is not really substantive negotiations, but it's really important to understand this condensed scene that we are observing.
What does moked mean?
Moked is focus. It's focus. So, but it's like how do we call it?
Center
It's like
arraignment hearings.
Arraignment hearings.
Where a judge just try to bring the parties to as many agreements.
So the idea is to close all the cases in these days. And finally, it's not finally. So we have an interesting also a phenomena here in Israel that all defendants are represented, so it's a very sophisticated scene of negotiation. They have to be represented by a lawyer. Many of the questions is about did he have, does he already have a defender, doesn't he have? So part of the Moked is having this sophisticated discourse between the parties. And lastly, we wanted to compare what happens to the civil terrain. Because in the civil cases that we observed, and we looked at the data and the court dockets, we found that most of the cases actually do not see a judge. So we have 70% of the cases that just reach the court, and the court is just, delivering the file, and the parties settle, some of them with no intervention of judges, some of them with some decisions that are given on written documents and not with a real encounter with the court. And then there are 90% of the cases that are disposed of pre-trial stages, and then 11% pursue to trial, and they keep settling also during the trial. But the idea in the criminal setting was not only to observe the criminal setting, but also to compare it to what happens in the civil case, and this will have some conclusions about it. And these are our research questions. Okay. So based on previous findings in the civil domain, we set out to examine what are the modes and degree of judicial intervention in criminal cases, to what extent judges are involved in what amount of cases, and given the Moked days and the possibility they created, do criminal judges, like their civil counterpart, exhibit substantive involvement in promoting settlement plea bargains? We found rich themes of intervention in the civil domain, and we documented them, and part of it was going to the criminal domain and trying to see what we find. And finally, what are the judicial practices, characteristics, and prevalence? What are the similarities and differences between judicial practices and civil and criminal cases? And trying finally to understand better this main door and maybe improve some of the interventions we have.
So following these questions, we went to conduct our study, and we did observation. Our research site was Tel Aviv Magistrate Court, which is one of 28 magistrate courts in Israel, but it handles 20% of all criminal cases. So it's a very busy place. We had 13 students, graduate students and law students, which were trained, and we built a special documentation of how to conduct the observation. They did it in 11 courtrooms, which means 11 different judges, and all in all, we observed 717 hearings in 704 cases by accident. When we checked everything, then we saw that the students observed the same case twice. So it was 45 Moked days. The numbers of hearings that are assigned for every judge run between 20, 30, and can be maximum of 70 even. Not such a fun day to go to work to, but we did kind of mixed methods. First, I will show the quantitative findings, because it gives us kind of an idea of the context in which the judges are working. So the Moked Day started, as we said, in the 1990s, and then they kind of sporadically they were handled in other courts, and they tried in 2011 there was a committee that discussed the efficiency of those Moked days. What we see that after 10 years, if the number of hearings if the number of hearings in No, I wanted to highlight. Between 210 and 211 was 3 or 3.4 hearings per case. Now it's 5.5 hearings. So efficiency-wise, something, I don't know. It wasn't the intentions. The lengths of a proceeding from the indictment till the closing of the case went from 286 to 584, and in percentage it makes it's more clear from 134% increase in the number of hearings and almost 200 in the lengths. But this wasn't our, this is not on our agenda. We just put it here on the table. Whoever is responsible.
Continuing is continuous. I love it.
The hearing outcomes out of 717. So we see that 4% of the cases are transferred maybe to community court or to a main trial. 80% are closed on the hearings that we observe, and 9% of the cases were in the final hearings, which is, oh my God, I wrote it down. Not sentencing, טיעונים לעונש.
Sentencing arguments?
Yes, sentencing arguments, okay. And what struck us the most, that almost 70% of the cases were rescheduled. So we dived in, and what we did, we took those 70%, which are the combination of the red and the blue together, and we clustered the factors that lead to these rescheduling to two subcategories. One category was factors that make it impossible to conduct the hearing. So this makes almost 50% of all the rescheduled hearings, and then the other cluster is all those factors that lead to a promotion, maybe to a plea bargain. Here it's a more detailed picture of the, oh my God. No, something went wrong in the numbers, okay. So believe me. Okay, so we get an idea. I remember by heart that defendant not showing constitutes 41% of all those factors, which is a lot. And if this committee thought that the defendants not showing would be more obvious in the first hearing, what we found that only 30% of the no-shows of defendant occurred in the first meeting. Defendants don't show, period. I mean, second, third, fifth, sixth hearing. And then we have a problem of completion of information. The defense didn't get what they needed. The prosecutor didn't get all kinds of things. Defense counseling matters, which means that the defendant appears when he's not represented. So everything is going around. It's not done before the hearing. It's all done during hearing. The other category, those of promoting, is that it's the hearing is rescheduled to make time and room for negotiations between the defense and between the parties, or they're waiting sometimes for a community court report if the defendant is eligible. So these are all the rescheduling. This is the atmosphere, the context where the judges are working. So now if we're looking for JCR, so first of all we can understand, we're looking where the judicial conflict resolution, where the activities are. So there's not much room because most of it is just really a managerial job. So we found, all in all, only in all those 717 hearings, we found only 149 actual activities that were in 121 hearings. A very tiny percent, minor percent, almost 17%. In the others, we didn't observe any judicial activity. Maybe there was, but we didn't see. And we divided it to 6 categories. We call them analytical categories for any methodologist that will ask us if the categories are distinct. No. Is there an overlap between the categories? Yes, of course, because if we talk about the first category, which is narrow facilitation, which makes the most of the judicial conflict resolution. Some can see it as a narrow or a broad, which I will soon address. The narrow facilitation is when usually the judge just sends the parties to conduct their negotiation outside. And for a quote, have you tried to negotiate here outside? Go outside with the prosecutor and close a deal. This is the most common quote that we found. Okay, I will be short because I don't know how much time I'm left. The other, which is an extension of this facilitation, is the broad facilitation, where really the judge tries to bridge a gap and to show the sides that they maybe each one can take a little step. He's more active in this facilitation. So what good will a postponement do? Take into consideration that if this is the proposal, it's not certain that it will change. So it tries to make them come closer. What we have to address in these observations are two things. First of all, in all those interventions, there is a carryover effect, which we found also in the civil court. Well, the court, people are sitting, the defendants and prosecutors and everybody. It looks like a very busy train station. So if the judge, she came this morning with a very good mood, so people will be affected. And if someone is very nervous and easily irritated, so people will be more careful. So this is this carryover effect. And another thing that they do it by this section 143A, they're not obliged to write everything in the protocol. So most of these quotes come just from the observation, and we didn't find them because we checked each protocol of each hearing and there was no mentioning of what the judge said. It's all in very clear, legal, formal language, but nothing more than this. Nigmar? Wow. Okay, so from the names of the categories, and you can read in our articles, you will understand the last thing.
Maybe the negative is important just to mention.
למה אף אחד לא אמר לי? לא, איפה זה negative? Okay. The legal aversion, which we found in the civil and in the criminal cases, where really the judges explain to the parties why they shouldn't proceed to a full-blown trial. It's not good for them, for the system. They will be punished more severely. Just take the offer and... can I one more?
Yeah.
What?
Negotiate.
Please.
We're in the right setting.
Yes. Where are your compassion skills?
Just wanted to.
What Mickey mentioned at the beginning, we see these 70% on the civil trial are those cases that don't see a judge. So the judges are active in the civil trials only in 30%. We found a lot of very lively and active involvement of judges in the civil cases, but they only deal with 30%. On the other hand, the criminal judges deal with the whole 100%, even if it's many hearings. So I don't think they have enough time to make a more substantive role, deal with it in a more way. Okay, Nikki, if you want, you have more power over the...
No, I mean, I'm just saying that finally, I mean, we have some similarities, some differences, but basically they both portray the trial as negative, and they are gatekeepers in this area. They are much more involved in the civil domain than in the criminal one. And part of our idea of going beyond it is to try maybe to have this active secretariat, or make them not really deal only with the more kind of technical aspect, to try really to speak about the more human dimension that happens in the court, to expand the horizons of concerns that they have when they approve a plea or when they deal with the defendant. I mean, since the Marquette days are the main door of criminal justice, I think one of the questions is how to make this door as a public sphere reflect deeper ideas about the role of law. And our research exposed the gaps that exist in this reality of managerial judging and the difference from the civil. And first step is to close the gap, and second is to improve both the raves by working with judges and other actors to improve this encounter.
And we'll move to Orna.
Yeah. I don't need. I'm asking. First of all, it's a great privilege to be here and to comment on this paper specifically. I'm sure many of you know, but for those who don't know, I think this project needs to be situated within the larger, I don't know how much you talked about, it was a little bit late, but this is really part of a pioneering, I would say, heroic project that is innovative in almost any level and parameter. Really, the topic, the research methods, the ambition. So this really needs to be put in place and within that context and read as one leg of that entire project. Mickey and her team are part of a small group that have really named and identified this emerging field of judicial conflict resolution and have had to deal with the need to develop new tools to actually measure what's going on the ground. I come to this comment as an old friend, but a novice in two of the aspects, as a novice in terms of the criminal milieu. In recent years, those of us coming from ADR have kind of tried to blur the boundaries between civil and criminal, and I think that's very much needed. And also as a novice to at least quantitative, but a definitely empirical, large-scale empirical project. I have my own, which I'm involved with my other academic half, who I'm learning from. So I'll try to offer some insights from this this perspective. By the way, sort of to connect to what was earlier in the day, we talked about lawyers who deal with capital punishment. I'm thinking here of lawyers who deal exclusively with civil versus criminal, and of judges who deal primarily or almost exclusively with one of the categories, and that's sort of coloring also how I'm thinking of it. So sorry for the stream of consciousness here. So I have a summary, but I feel like it's not, I'm not sure how necessary it is to go into this, but we see that we have an empirical examination of a little over 700 cases, and we have a mixed methods approach. And this elusive nature of the JCR interventions really require developing the novel tools for recording and conceptualizing what judges are actually doing. And as you rightly notice or remark in the paper, these interventions have no documentation in the transcription, nor can they have. And we can't even imagine. I don't think the judges themselves are aware. I mean, even if we were able to interview the judges, and in Israel we cannot, absent a formal approval, to interview the judges. Even if we were able, I don't think they would be aware of half of the things they were doing. So in that respect, this is really also another reason for this importance. And so the findings go along two comparative axes, right? One comparative axis is within the criminal domain, comparing the Marquette days recently with Marquette a few years ago, using primarily objective quantitative measures. And then the other objective lens is comparing sort of from the recent projects, the criminal with the civil, drawing both on the objective measures and the observations in court. And here, basically, the findings are that in the criminal domain, the efficiency has gone down as measured by number of sessions and length of case. And what economists would probably tell us is a thin vision of efficiency. I'm still waiting to grasp the full vision. But in the civil domain, we see sort of also a thinner version of the judicial interventions that come into play later in the game, right? That's I would like to offer comments along these axes, And I have to say, first of all, that just seeing these findings was super interesting, and my initial reaction was, how do I think about these findings? What do they mean? And of course, my other academic half always tells me that's not what empirical projects do. They show, they don't explain so much. They don't. Well, but so I'm offering another stream of consciousness on where this may lead us, and maybe an idea will strike you as fruitful, or as something you may want to say is irrelevant. We discussed earlier there were a few methodological issues, which there's always a trade-off. If you have a large enough pool, you can, as what I've learned, you can analyze into more and more categories, and then actually account or dismiss alternative explanations. The smaller the pool there is, it's very difficult to do that, and that's fine. It doesn't mean that you cannot show the findings. It may be worthwhile to think of alternative ways to answer the alternative explanations, and there are many excellent empirical works that do that, even where the data doesn't allow. And I think intuitively, I feel the finding is very strong, so I don't think you will have a problem to come up with that as well. But I'm convinced, and I'm taking the finding that efficiency has dropped, which is amazing, and certainly counterintuitive for the justice system, for the administration. And I was asking myself, what can be a story we tell about that? So one possible story is maybe, and it's kind of counterintuitive, I think, maybe what we're seeing is a decline in efficiency and a rise in fairness, or at least some perception of what fairness is, or maybe process and not necessarily fairness. And as many of us know, in the dispute resolution literature, we typically assume there is a trade-off between fairness and procedural efficiency. Efficiency means quick and inexpensive procedures, while adopting more rigorous and lengthy procedural safeguards is thought to ensure the fairness of legal proceedings and outcomes. And indeed, that's why we accept the principle of proportionality, right? So when it's small-scale cases, we think they can go to small claims and go through this quick process. You see, even my examples are civil. And as the stakes are higher, we have the super due process. And we expect the pendulum to shift towards more fairness. And this was also the source of many of the critiques against ADR processes and managerial judging, right? That they place too much significance on efficiency, hailing the speed, convenience, flexibility, and low cost, while foregoing important safeguards that may encumber the process, but are important for ensuring parties, informed consent, equality, anything we value in due process. Proponents of ADR have addressed these issues, these critiques, attacks in several different ways. Some accept the trade-off and say, yeah, we want efficiency. Others say the trade-off is relevant for legal proceedings, but not for ADR, because in ADR you can't really measure what you get in the same way, and the legal outcome is not an indication of the fairness. That's why they may frown upon managerial judging while viewing ADR processes as operating on a different sphere. Could it be that the decline in efficiency and reserved judicial intervention and these sort of repetitive meetings actually present an attempt to enhance the fairness? Certainly, there's still more. We don't think it, right? So we could. So I'm throwing out ideas how we might be able to measure. I don't think in this project, maybe, when we have more cases, but actually looking at the outcome at the end of the case, I think could be beneficial in that respect, and comparing those. Are more cases referred to restorative justice and then taking more time over time? That'd be interesting. In terms of the current research, the coding of the statements under, and I talked to you about this just a few minutes ago, under the client, that what you call the triangle, the client-lawyer-judge relationship, to me, when I read the examples, and I just read a few, it sounded like procedural justice. It sounded like a place where defendants and the lawyers get a voice. and almost maybe even more than procedural justice, interactional justice. And I thought that's something you could work with, and maybe what's happening is this is getting more space and this is taking more time. I don't know. Alternatively, I was thinking maybe what's happening is they're saying if no process can take place, if this is a vacuum in terms of process, then maybe it's sort of in the Shapiro kind of way, you know, either we get legitimacy through many rules or we get it through consent, so we're not going to hold this until we have the defendant present, we get their consent, you know, sort of get them on board, and then they're looking for consent to build legitimacy, throwing out ideas. So a second point, not related to the drop in efficiency, has to do with the nature of judicial intervention, the various tools you recognize. So as we know, in the aftermath of the adoption of alternative dispute resolution in the 70s, this concept of process pluralism has gained traction. A concept which highlights the ideal, the desirability of there being a wide selection of processes in our justice system, each with its own moral integrity, goals, values, and in that sense, expanding access to justice. And I found it fascinating that the judge's intervention in the criminal setting differ from the civil cases, and I was asking myself, what's happening here? Could it be, and these are all issues you raised, could it be the different structure, the fact that there's a judge here that stays the same judge versus a judge who changes in the civil context? Could it be the timing, which you also mentioned, of the lawyers showing up? You know, the lawyers are so instrumental in the civil context. And one of the questions I keep staying with is, can we think of a variety of these sort of ADR-like processes being institutionalized in the court setting and employed by judges without co-opting their alternative nature? Can we create a plural setting in courts, or are we simply substituting one main door, the court proceedings, with another, which is plea bargaining? In contemplating these questions, it seems to me that finding significant judicial energy is devoted to promoting settlement by depicting the dangers and negative aspects of going through the full-fledged legal proceedings is particularly important. We sort of know it, but we know mediators do it all the time, right? But thinking of judges saying that about the system they serve, there's something so unhealthy about that.
It's a bad
and just depicting the negative, really, without, as you rightly say, without some kind of positive vision of what it is they're gaining when they take the alternative, not just because of the fear of litigation or of legal proceeding. And then you indeed highlight the lack of positive understanding of plea bargaining, describe the role of the judge as a gatekeeper, which I think is very accurate and does go with the passive stance that you highlight. And I'm throwing out a potential future project, and we've discussed the difficulties. What you're doing is so novel in terms of research methods. I don't know if this is possible, but if you could tie the types of judicial interventions, we talked how difficult it is, with different case types, with history of defendants, with different outcomes at the end of the process. I realize this is, an almost impossible task, maybe impossible, but I think that would be amazing, and could really shed light and generate learning on these dynamics and the connections. Could help draw, as you say, the contours of the use of JDR tools that would generate a more plural, perhaps more positive, maybe not necessarily more efficient future dispute resolution landscape. So thank you.
Great. Thank you. Okay, so we can open the floor for please, Kel.
I feel bad asking a question because Orna raised so many questions. We could spend the rest of the time talking about yours. But a question that I have, just listening to, especially about the judge's role. So a thing we have in the U.S., that judges don't like this term at all, but it's a real thing. We call it the trial penalty. Like how worse a sentence will a defendant get if they actually do go to trial than if they resolve the case prior to trial. And of course, this varies tremendously across the country and in different courts, even in the same place. But on average, the trial penalty in the US is about 300%. So that if you go to trial, you will end up with a sentence 3 times as long as you would get if you plead guilty, which may explain the 97% plea bargain rate in the US. So I'm just wondering, one, is there a trial penalty? There must be. What is it? Do judges recognize it? And how do you, is that part of their predicting of outcomes? You know, how do they advert to that in terms of, you know, if you want them to have a bigger role, like that's their stick. Should they, you know, surface that that's really what's going on, or is that not, you know, what one has in mind for judicial management in this context?
Okay, so maybe I'll answer.
Maybe I'll just ask
Okay.
some questions so that you can, you know, answer. Yeah, please, Corey.
One is maybe just sort of a technical question. I'm wondering when you're talking about the transcripts of the trials, about what goes in and what doesn't go in. You know, are judges instructing the folks doing the recording, don't put that in? Is that an unspoken thing? And maybe the next panel talking about transparency, and this is also a transparency issue, but that seems to me the norms about what gets recorded, you know, seems like something potentially to explore. And I also wanted to ask, and I know this is part of a larger project, I wonder what the interplay is between the other stakeholders in the room. So if you have a judge pushing for, you know, people to do some other kind of resolution, are they doing that because maybe the prosecutors and the public defenders are saying, please help us out, push a little bit, or are they saying no, or the pushback? And so I'm sort of wondering, in your observation, what was the interplay of the other stakeholders who have power and voice, or do they? So.
Great. Okay. Flo, please.
I'm impressed with the concept itself of judicial conflict resolution. In that terms, I would think in terms of civil cases, because a conflict is not exactly the same as an offense. In an offense, you have also the public dimension. So I wonder whether that is not the reason why it is so-called less efficient, because the judges themselves are puzzled with this ambiguous position where they are. And the second puzzling for me is the term efficiency. Of course, efficient according to the judges, but for example, the feeling of procedural justice as Tyler launched as an idea may be very much efficiently terms. That's another thing.
Malcolm.
Yeah, thanks very much. I've been watching this project from afar for a long time. I had two questions. One is, I wonder if there is a decline in efficiency. The delay may suggest exactly the reverse. That is, a higher portion of people will plead guilty and will accept the outcome if they go on a little bit. And then so it may show just the reverse. And so if you could look at the outcomes, connect the outcomes with the delay and over time, it'd be okay. Secondly, you said that huge numbers of people are no-shows, and how you figure, and so I can't quite understand how you figure the number of hearings and so on and the no-shows. It may be totally a function of how no-shows are dealt with as well. No-show, and finally show at the 5th time, so maybe things have changed over time. Secondly, what's really interesting is Israel doesn't have a jury trial system, and the main explanation for why there's so much plea bargaining in the United States is the jury trial takes forever, but you don't have one. Now in Philadelphia, they used to have, I think they still have, bench trials right and left, and they take roughly the same time, maybe 10% longer than bench trials. So the question is, why doesn't Israel have lots and lots of bench trials? Now you have the crazy American rules of evidence for no reason, given the fact that you don't have juries, but nevertheless, why aren't there more bench trials as the American hypothesis would lead us to expect?
So maybe I also ask the question.
One more.
Yeah. Okay, yeah, Rick, please.
I'm like hanging out down here in the corner. Well, sort of follows up on a couple of the questions that have already been asked. I don't know if there's anything like bail in Israel or not, but one thing that would maybe worry me a little bit about a system in which judges are more actively trying to encourage people to go outside and close a deal with the prosecutor is if there are things, especially if there are things like bail, but even if there aren't, you might get a lot of innocent people getting pushed, right, to plead in, especially in these low-level offenses where it's just worth their time to get this over with. And that can have a really damaging effect, obviously, because these are show up on your record, and they're sort of gateways into the criminal system. And so Sasha Nadaboff has written about this pretty powerfully, about how it's a big problem in the United States. And I would just encourage you to maybe think about looking at that aspect of this as well when you're thinking about, is it kind of good to close the gap between civil and criminal or not? Because I could see, the argument sort of being the other way. We actually want it to be as inefficient as possible, and to really push back on innocent people getting forced into this system, and where they have every incentive to plead out quickly.
Great. So maybe just last question from me, and you don't have to answer everything. It's more for you to think. I was just wondering while reading the paper. About it ties back to Malcolm's writing from the end of the 70s, exactly, the process of the punishment. And on the one hand, you describe a system which is very bureaucratic and managerial, and you say that most of the judge's role was confined to managerial bureaucratic decisions, and only in very small cases you see that the judge took an active role. But on the other hand, you do describe some discretion that the court has there. And if I had to ask you, to push you to the corner and ask you, what would be more accurate to your opinions, how would you describe the system? More bureaucratic and managerial oriented, or more open space, if to use Malcolm's phrase, more a system that still, handles cases very swiftly and very busy, but still can differentiate between cases and use discretion. So. You have 2 minutes.
Yes, the no-shows, we counted them. I mean, technical answers would be on my part. The no-shows, we counted them at the hearing because the judge is sitting, the prosecutor and the defense lawyer, and they're sometimes waiting, and then they have a discussion as to habeas corpus, you call it, or I don't know, the legal terms. So there's time wasted. So we counted it as a hearing because it's, I say, if you have to go to work in the morning and you have all this list, and some of this, yes, most of it, you see 70% is technical, managerial, bureaucratic. They don't have this, they don't have that. And it's not meaningful. And you described it in your article. It's like a very busy train station, like a factory. And when talking about what's in and out the protocols, just to describe the setting, you have to be very fast, very quick. The students came with a list of the cases dealt with, but the lawyers are sitting with the back, and I don't know why they don't have any mics, and they're whispering to the judge. So you're trying to complete sentences, and the judge. Now they're familiar with one another, so nobody bothers to say, "Okay, now we're dealing with case number this made the difference." Everything just goes on, kind of. They came to work. It's another working day, and we are the observers. We don't see that the judge tells the typist not to record. I think most of it, the females, she knows it. Everything else is recorded in details, what the defendant, what every lawyer said, but not what the judge. I think it's a habit already.
Okay, I'll try to answer a few together if I manage. But in terms of the protocol, it's really different from the civil case, and it's more like it's not a mediation scene, it's not a conflict resolution scene, but the fact that all these arguments are not even considered something that should be written in the record is part of this idea that this judge is actually trying to do his best to close the case, but it's not that later, like in the civil case, we have the same presiding judge deciding it. So it's very important for the parties what is written, what is not. Sometimes they challenge it and they appeal it. In the criminal case, the judge is there as a judge, but not as a judge, as a certain mediator that later everything is confidential. And it's, but considering the bench trial, it's related also to the question of the activity. In Israel, I think we took it really very far, the idea of reaching agreement. And it goes to the level of more severe cases. If they don't manage to be plea bargain, they go to a process that we'll talk later, this criminal mediation. Also, non-presiding judges, not in a Marquette hearing, sitting only with the parties, trying to persuade them to reach a plea and to help them close the gaps. And it can be in rape cases, and it can be in very severe crime. So the whole idea that there is the real thing, that is the trial, but there is a more preferred way that sometimes even judges say this is more inquisitorial, that helps us to be more. No, we see the evidence, we see everything. And this is not by a judge that decides, but it's a judge. So it's this negotiated justice that becomes the rule. And therefore, the question, if you ask about the trial penalty, I think there is not even the shadow today of the trial. It's almost like insane, or I mean, who is the person? And they can also not control it. So the person who really persists on going to trial, or the defense attorney, they will be considered as troublemakers. I don't know if part of the theory here of one of our team group, Yosef, in his dissertation was a game theory, a theory that says that actually it became really much more dangerous today to go to trial because this is in the shadow of bargaining, or it's not in the shadow of law that you conduct the trial. But the whole idea, and also this negative portrayal of the trial, is that it is not reasonable to pursue it. And in Israel, and this is speaking about the conflict, the question of the judicial conflict resolution and the difference between a dispute, I think there is a lot of issues. There are two issues at least that are at stake if we speak about the criminal plea bargain. In Israel, we negotiate both the charge and both the sentence. And in the two of them, you have some bargaining terrain, and you have some possibility to expand the role of the judge, meaning making sure that the defendant really takes responsibility, understand what it does, that what is written in the verdict is really what was happening. Sometimes nobody agrees that this is what was happening. Sometimes it's something that was stipulated in order to justify the sentence. And then when you get to the sentence, thinking about rehabilitation, thinking about preventing the next crime, addressing the concerns of a person that doesn't have a home, doesn't have a perfume. And if you speak about the bail, these are very small cases, not cases that go, it's not, we don't speak here about people that are arrested, and therefore the considerations are differently. Obviously, we have this fear about people pleading guilty, but we have the public defenders, and they are there for all small crimes. So in that sense, this is a balanced area in which they know what other got, and they're supposed to defend them. But I think part of the problem we see, and this is related to your critique about and the suggestion of efficiency, or more justice, the kind of justice that the system can provide with the setting of adjudication and the trial being the norm is very limited. So it may be the case that today there are more hearings in which we understand really about what is the charge and what is the sentence, and we know that the defendant really accepted it, but the judge cannot really address the victim. In all the 700 cases, we have almost find a few cases in which the victims was there or addressed at all. The judge cannot really address claims that are different. Like, sometimes the defendant can say, but I didn't do, or I did this or that, and then he will just be sent out. Sorry. And therefore, the whole focus of the judge, even if there is a procedure of justice, is this narrow perspective of closing gaps, of helping to facilitate a deal. It's an alienated discourse, and it's remote from reality. And sometimes the judge here is really addressing one question in terms of the players. He's supposed to really convince the defendant that there is a real deal here and that is not really sold by the public defense attorney, and there is this play between the players and they try to do the best, but what I think I'm feeling is that since instead of the idea that we have to finish the case there and that it's not good to go to trial, there is not another idea of whether we're doing it in terms of we can help them get into a consent, but the whole deal of the criminal justice small cases that we have is not a very promising one. So my perspective about the possibility of judges to have more sincere engagement is that it needs to be nourished and really we need to do much more work in order for it to improve.
Great.